Okay. Welcome to the July 12th, 2011 joint meeting of the Glendale City Council, the Glendale Redevelopment Agency, and the Glendale Housing Authority. Can we have a roll call for the council, please?
Council members Manukian.
Here.
Najarian.
Here.
Quintero.
Here.
Weaver.
Here.
Mayor Friedman.
Here.
And roll call for redevelopment, please.
Agency members Friedman.
Here.
Najarian.
Here.
Quintero.
Here.
Weaver.
Here.
Chair Manukian.
Here.
Roll call for the Housing Authority.
Authority members Friedman.
Here.
Manukian.
Here.
Incy.
Here.
Najarian.
Here.
Brazian.
Here.
Weaver.
Here.
Quintero.
Here.
We hear your report, please.
Agenda for the July 12, 2011 joint meeting of the Glendale City Council, Redevelopment Agency, and Housing Authority was posted on Thursday, July 7, 2011 on the bulletin board outside City Hall. Before three bodies today as Director of Community Development regarding urgency ordinance and other actions authorizing the City of Glendale and Glendale Redevelopment Agency to participate in the Alternative Voluntary Redevelopment Program. 1A is urgency ordinance for introduction authorizing participation in the Alternative Voluntary Redevelopment Program. 1B is ordinance for introduction authorizing participation in the Alternative Voluntary Redevelopment Program. C is a council resolution authorizing the execution of a remittance agreement. D is an agency resolution authorizing an execution of a remittance agreement. E is a council resolution reducing the allocation to the low and moderate income housing fund for the 2011-2012 fiscal year and making certain findings and determinations. F is agency resolution reducing the allocation to the low and moderate income housing fund for the 2011-2012 fiscal year and making certain findings and determination. And G is authority resolution reducing the allocation of the low and moderate income housing fund for the 2011-12 fiscal year and making certain findings and determinations.
Thank you. Mr. Starberg, can we hear the bad news?
Yes, I'll go to Jillian Van Meiden, General Counsel, for the staff report.
Thank you, Jim. Madam Mayor, members of the council, chairs, members of the Housing Authority and Agency. What you have before you today are a number of actions that are related to the recently enacted legislation to eliminate redevelopment and its partner bill, and that is a voluntary alternative redevelopment program, or VARP, as we like to call it. And what we're asking you to consider today is based on staff's evaluation of its ability to participate in the opt-in or the VARP program to adopt an ordinance on an urgency basis to allow the agency to continue to conduct its activities based on the provisions in that ordinance, and which require the agency to make certain voluntary payments based on a calculation made by the Department of Finance that reflects a proportionate share of Glendale Redevelopment Agency's contribution to $1.7 billion, which is the statewide estimate of redevelopment funds that are currently existing that the state believes will help it achieve its balance its budget and is part of its balanced budget program. These were trailer bills to the budget bill. So what you have, again, as I've stated, is an urgency ordinance which provides factual basis for the council to take an immediate action after introduction, so that would be next week upon your vote, to allow the agency to participate in this voluntary program requiring these payments. In the fiscal impact section of the report, based on our best estimates right now, which do not reflect the recent bonding activity that took place in 2011 and 2012, and acknowledging that the figures that the state is using come from the 2008 and 2009 fiscal year, it looks like that our fiscal year 2011-2012 payment will be approximately $11.9 million, and then in 2013 will $2.8 million. Based on our internal discussions with our finance director, we are able to make those payments, and therefore are recommending that the agency and the city participate in the VARP program. How that works is not that the agency would make the payment directly to the county for submission to the state, but that the obligation to make the actual payment comes from the community, meaning the city. And therefore, there are additional actions that we're asking you to take that include a remittance agreement between the city and the agency, so that those to ensure that the logistics of those payments can be made, and also in the event that there isn't enough money and that our calculations are somehow not accurate, that we can lower the amount of set-aside. Right now, we devote 20% of our tax increment to our low and moderate income housing fund. That's the 20%. Right now, we calculate that we're able to make these payments out of the 80%. However, in the event that we are in error or are unable to make those payments, we're asking you also to consider adopting resolutions that would allow us to lower that amount of set-aside so that the city can fulfill its obligation to make the payment. Those are the actions that are in front of you today. What we're asking you to do is to introduce the ordinance on an urgency basis, and then next week at a regular City Council meeting, on the adoption of that ordinance, we'll be asking you to take the following actions, and that would be to execute the remittance agreements and to authorize the allocation of potentially less than the full 20% to our low and moderate income housing fund. So that's a description of the actions that we're asking you to take, the reason why we're asking you to take them, and I'm available to answer any questions you have about the legislation or the legislation eliminating redevelopment or the VARP program or the actions that are in front of you today.
Are A and B agency introductions?
Their council. The first is the urgency ordinance that requires a 4/5 vote.
Okay, because the others tell us council, agency, authority, but the first two are council.
And in the event there is not the 4/5 vote, the ordinance would take its ordinary course of action. That would be introduced, voted upon. It would not take effect immediately upon adoption. It would be 30 days
Right.
after.
Why is there a need for an urgency ordinance at this point?
At this point in time, our activities are technically suspended. We cannot enter into new agreements. About the only thing that we're able to do at this point in time, and I would ask Mike Garcia to chime in as well on this, from our understanding, based on our reading of the ordinance, is to take actions that would prevent defaults under existing agreements and to preserve agency assets.
Defaults by?
A default by the agency in the event we needed to take an action. The agency needed to take an action in order to preserve its assets or to undertake its obligations, and otherwise we would end up in default under those agreements.
You mean payments for the bonds and such?
Payments for bonds, for example. Yes, that would be an excellent example.
If I may, Madam Mayor, members of Council and Housing Authority and Agency, we would be able to take any actions necessary to implement what's called our enforceable obligations. So to the extent we have existing agreements and we have to do additional things to implement those agreements we're entitled to, but we're not allowed to enter into any new agreements. And that covers the broad array of activities that the agency funds, including, for example, things like single-family rehab agreements that are administered by staff, and we can't even enter into those agreements during the suspension period. So the immediate adoption or the immediate effectiveness of the ordinance would allow the agency and the housing authority that implements the set-aside fund to continue to do the execution of new agreements that they may administer at the staff level, as well as some of the additional things that are identified in the urgency ordinance.
I thought we didn't have enough money for this, and this would basically shut down the redevelopment agency. Now it seems like we have money to pay them?
Well, I was going to comment on that. Under the fiscal impacts, we believe we have adequate cash flow to make the payments, but the activities of the redevelopment agency from the standpoint of fiscally participating will be significantly curtailed over the life, certainly of the central project area, and for some time to come for the San Fernando Road project. Payment of $12 million, we believe we can meet it, although, again, the final numbers haven't been issued yet. There's actually two different calculations, one for the first-year payment, which we're estimating to be about $12 million, and there's a separate calculation that's utilized for the ongoing payments. We're making estimates now as to what we think those will be, and it's based on those estimates that we believe we can fit it within our cash flow for the central project area and for San Fernando. But Central Project will have very little remaining disposable income for the ensuing years, maybe in the area of $2 million disposable each year. We believe, however, that maintaining our rights to essentially utilize the redevelopment tools are worth keeping the agency alive.
What is the life of the central project area?
Central project's about 5 more years.
2015, August 2015.
So 4 more years, then you have,
Is it
you have
worth-
10 years of paying for debt following that.
Does it make sense paying $12 million and, $3 million from now on?
We
For
believe
3
it does.
years, which will mean another $12 million? So $24 million over the next 5 years?
Keep in mind, they will take
They'll take it
everything
all.
if you don't continue in existence. So you won't even have that. And you'll have an oversight committee that then will be essentially responsible for administering your ongoing development agreements as well as unwinding any existing assets that you may have in an effort to maximize the repayment of the taxing jurisdictions. So in the absence of remaining alive, then you fall into the essentially going out of business, being disposed of process, which has an oversight committee coming in attempting to maximize the return of the taxing jurisdictions. We just don't believe that's in the best interest of Glendale.
And the maximization of the value includes not just soft assets, but also hard assets, and would involve unwinding deals, cooperation agreements, and other agreements that were entered into since January 1st. So it's quite draconian impact that would have on the work that we have done to this point and that we're anticipating to do, and it's for that reason that we've recommended it on an urgency basis so that we can not lose the $3.1 million that we have in home funds that are required to be committed in addition to our over $600,000 in set-aside before the end of this month, plus a number of other projects that we are currently administering under existing leases, such as the Museum of Modern Neon Art project and disposition and development agreements we have with the Courtyard Marriott project, as well as
the amendment of the Lemley project.
the amendment of the Lemley
Vision of
project.
parking there.
Exactly.
And I
That's
might
correct.
note that the non-urgency ordinance requires 30 days to be effective after its adoption. So during that 30 days, if we didn't utilize the urgency ordinance, we wouldn't be able to take any of those actions during the 30 days while the non-urgency ordinance is becoming effective,
And we would lose the $3.1 million in home funds for the Mercy
as a
House.
minimum.
I have a couple of questions. Assuming for a minute that there's a possibility that the lawsuit that's being brought by the CRA and the League of California Cities against the state is successful and the redevelopment agency's ability to exist is upheld, what then would happen with the payout that we make? Do we have any chance of getting that back, or is it just we rolled the dice and we kind of lost and won at the same time?
Well, let me reflect what we've learned through some of the conferences and some of the CRA board meetings that we've all been engaged in. If the stay is granted, then there shouldn't be any payments, so they won't be a risk. If the stay isn't granted, then I think we have serious problems with
When will
respect-
that be determined? When will the stay be?
Well, the stay would
When
be
is the
filed-
hearing? I'll put it
the
down.
stay would be filed within days, I would think.
Okay.
I don't know. Did they estimate how long they thought for a hearing?
So it's not months, it's weeks.
No, it's days or weeks on the stay.
Well, I think they were anticipating filing soon, within days, but they probably wouldn't actually get a hearing before the court until mid-August. I think that's what they're shooting for. But the payment isn't due until January, which, first half of January. So I
First
think
half is January, second half is
March.
March?
March or May?
It's May.
May.
So the intent is to have the entire litigation resolved by then, but we can't say what that's going to
Based on
happen.
the previous litigation over the ERAF shifts, without a stay, you'd be making your payment and then litigating it because the litigation won't be resolved by the payment dates.
So, going back to the affordable housing component, why not reduce the affordable housing set aside proportionally to other programs that we're going to be? I mean, it seems like so let me just be sure I understand this. We're going to pay this it's $11.8
Call it $12
million. It's $12 million, but we're going to leave the affordable housing set aside at the same rate. Why not reduce that as well so that we have some money left for economic development?
You probably don't have a basis to make the reduction unless it's for the purpose of making this payment. Your 20% obligation is required into affordable housing. That's part of your
Is
responsibility
it
for an agency.
20% of what's left or 20%
No,
of the
it's
entire
20%
amount?
of your gross tax
Right.
increment.
I think you have to pay as much from the 80% as you can, and then to the extent you need to dip
You'd
into the
have- You'd have to make
20%.
a finding that you couldn't make the payment from your 80%, and then you can,
Right.
I think, essentially borrow from your housing component to help you make the payment. We're only asking for the action on the remittance because we don't know the exact number yet, and it may be that we may not have adequate 80% money to make the full payment, in which case we may have to draw on the 20%, and we'd come back and report that to you.
So it's 20% of a tax increment, even though they're not letting us keep
That's right.
the tax increment.
And let me, in the same vein, I was just listening to the webcast by the executive director of the CRA and the general counsel of the CRA. They also noted that, for example, these payments for those agencies that have dollar caps on their project areas, many agencies have a maximum total amount of tax increment they can draw over the life of the project area. These payments will actually count toward that. In years past, when the state has taken redevelopment money, they allow you to not have those payments to the state count against your cap, because that money isn't going to benefit the communities locally. They didn't even include that in this legislation. So many of these things seem patently unfair, but that's just the way the legislation was
How did
drafted.
those caps come about?
They were negotiated at the time that the agencies came into existence. We don't happen to have that kind of a cap in our central project area, I don't believe.
No.
But many did. But many did have caps. LACRA, for example, had a cap, and they sought special legislation to increase it a number of years ago.
What is our yearly tax increment about
Both projects combined, Mark? About $35 million.
per?
No,
that total?
that's combined between the two project areas.
What
central.
about per year? So next year, when we pay the $2.5 million, will we have any money that's accrued that will be excess funds, or is it the entire
The estimate was a couple of $1 million a year, in all likelihood.
that we're accruing?
So that we'd still have, I'll call it as disposable.
But if this year you're paying $12 million and you're okay, and next year you're paying $2 million, you're basically paying $10 million less, shouldn't you have that much more?
No, the $12 million is being made up of resources that we've built up, redevelopment.
Is it coming from the
Part
reserves?
of our ongoing.
Is it coming from the reserve?
Coming from fund balance. We don't call them reserves, but essentially fund
Okay,
balance.
fund balance.
Yeah,
So it's the accumulation it's coming from.
that's right.
So it's not the ongoing operation.
No.
It should also be noted that the reason we're asking for the flexibility to dip into the 20% is that we may not be able to make the payment out of the 80%, but also that applies in the first year only.
But see, that's what I don't understand. If it's coming from, if it's coming from the fund balance, then it's not coming from the current year's 80%, right? The $12 million?
By the current year, I'm sorry,
The
go ahead.
portion is, and we're having to make a payment both utilizing our ongoing 80% tax
Okay.
increment as well as funds we have built up and had planned to use for other projects. So we're essentially utilizing existing resources, both built up over time as well as our ongoing tax increment to make the payment.
And how much are the balances? How much money do we have in the fund balance?
I don't know offhand. I don't have the cash flow with me. We'll be happy. Mark has worked on the cash flow. We'll be happy to provide you with a copy
Okay.
of it. And it shows the running balance to date as well as how this draws it down.
We had this recently when we went through the redevelopment
Right,
projects. We
right.
saw it.
And we should also have the amount of the tax increment annually that we receive.
Right, it's on the
That's the
cash flow.
question that the mayor asked.
You'll see it on Mark's cash flow.
Najarian?
I'm not sure I understood under what authority we can dip into the low and moderate income housing fund money to pay.
It's in the statute. It allows us to do it for this year. In the legislation that was just adopted,
Okay.
it's in allowing us to do it for this year only.
Okay, but that's discretionary, right? I mean, that's a policy decision that we make
That's right.
if we want to.
Right.
That's right.
The low income
What
housing.
do you mean discretionary? That's not what we said. We said if you can't meet it with the 80%, then you have the option. Then you have
The option.
the
But
option.
let's be clear.
Yeah.
Let's say we can't meet it with the 80%. If you then tell us we can't then meet it utilizing our housing set-aside, we have no other alternative but to not make the payment, in which case we go out of existence. So you have to make the payment in order to continue your agency's life. If you don't have enough with your 80%, you are permitted to essentially borrow for your first year payment from your housing
I
set-aside.
think it's the term discretionary.
Well, discretionary is you can either decide to make the payment or not make the payment. If you don't make the payment, then you go out of existence.
Okay, and this is coming from fund balances that are.
Partly.
In the housing fund, if we needed to use anything, it would be the fund balances or the ongoing 20% set-aside.
And right now, we're not anticipating using the fund
No,
balance.
we're not anticipating having to
So,
use
be
it.
clear about that.
Right.
I mean, I think this is probably as good as time as any to bring up a painful subject, and that is what are we going to do with continued staffing of redevelopment? I think that's a problem. We can't continue with the full staffing level when the agency funds are getting gutted.
Well, I don't disagree, and we
Yeah, I mean-
we do have to look at that.
And the sooner we look at it, the better, because, these are ongoing expenses that if we have to do something about, we need to.
And we'll have some sense of that when we get an answer on the stay. I mean, the first indication of whether we have to essentially walk down the road of potentially unwinding our activities will be whether or not we're successful with the stay, and how the court may limit what we're able to do under that stay. That may be a stay that says everything's set aside, you got carte blanche to do everything you'd normally do, or it may contain a number of limitations. So we may get some glimmer of how the court will eventually act depending on how they act on the stay. And that should happen fairly quickly.
I mean, I was just introduced to a young lady that was brought on staff. I'm not sure I see the wisdom of actually adding on at this point, regardless of how important a role she would play in whatever her particular role is, when we're going to be, taking out the chopping block and maybe issuing layoff notices.
I don't believe she's regular full-time staff. She's hourly position, working on hourly.
I mean, I'm just in a general sense.
I don't disagree. We're being very sensitive to that.
This is the worst-case scenario that we saw coming, and it was very quiet, though. I mean, it sort of crept up on us, and here it is now. And I'm sort of getting the sense that we're always hoping that it would never happen, but this is really something that we have to deal with, and it is going to be painful, I think, for everyone involved.
It will be. We'll see our first indications with the court's action on the motion for a stay.
Mr. Quintero.
Well, I support the ordinance and the resolutions, but I can't help but comment that George Orwell is alive and well in Sacramento, because remember, ABX 127 is the Voluntary Alternative Redevelopment Program that the state has put before us. I repeat, the Voluntary Alternative Redevelopment Program. There is no alternative here. I mean, the alternative is either give money to the state, which will be passed on to the other taxing authorities,
Or let the state take it.
or let the state take it. And then I'm also kind of chuckling at remittance, the remittance agreement, which kind of reminds me of something that, my grandmother might have gotten in the mail. Send your remittance to the Catholic Church. Anyway, the blood money, I think, would be a better way to describe it. But I think this is the right approach. We have to do this, hope for the best. When the courts, starting with the judge, but then I'm sure going on into the appellate scene. And let's hope that we can rescue something out of this whole debacle, because while I do believe redevelopment needed reform, what's come down from the state far surpasses anything that I had in mind, and most of the individuals that I spoke to at the conference that we attended this weekend. I do support the ordinance and resolutions.
Any further discussion?
I have a question. So in case the council and the agency adopts the ordinance, maybe my question is not to the point. So are we going to still have redevelopment set aside money? Because I remember we were using some of this money for the housing projects.
Well, if these measures are adopted by the City Council, then the answer is yes. We're not sure whether we'll have the same level, but the life of both project areas should continue, and regardless of whether or not the litigation over AB 1X, 26, and 27 is successful, with these adoptions, the worst case is we make the extortion payment, but life continues, in which case there would still be housing set-aside funds.
Okay, if there's no further...
Just a question that popped in. Does this affect the mandatory low-income units that a developer has to build if he's building it in the project area?
The inclusionary requirements?
Right. Does this affect that at all?
Mr. Najarian, the inclusionary requirement, remember, it's a requirement of the agency, and we were sort of passing that along. We're still implementing it for sale projects, but no longer for rental projects after the Palmer case. And so the answer is yes. Essentially, we would still have all the obligations under redevelopment law
So if
that
the
pertain to
life of
affordable housing.
if the life of a project area continues, then all of those
Right.
things would still apply. If the life of the agency terminates, then those are all gone.
I know that was a special concern to several developers who've come before us. Precedent to have that inclusionary house. Anyway, that's...
Madam Mayor, if I could just bring to your attention, what was placed before you was a revised urgency ordinance. What we included in that ordinance were a couple of more specifics in Section 9 concerning the impact, immediate impact on the Mercy Housing project with the loss of the $3.1 million, as well as our inability to administer existing agreements relative to some of the projects that we discussed. So those are the distinctions between the one that was in your packet and the revised urgency ordinance. So we're asking that the revised urgency ordinance.
Would you like some action?
Yes, please.
I'd like to introduce the urgency ordinance at 1A. As revised, yes.
Okay.
I'd like to introduce the ordinance at 1B for the council,
1B is
authorizing participation in
for the council.
That's council too.
Okay.
I'll move 1C for the council.
Second?
Okay, can we have a roll?
Want the remittance agreements now?
Actually, can he do all of the council resolutions at once? That would be C and E? Yes.
Those will carry over to the regular city council meeting, which will also be
So not here.
not here. They will carry over once we have the authorization.
So B and A will come back to you at an evening meeting next week for adoption, and then we'll have the agency resolution, or the council resolutions at that time?
Council agency,
So we can do the agency and the authority now.
yes.
Then I'll move
Can we do
one.
both agencies at once?
I'll move then 1D and 1F for the agency.
Second.
1D and 1F, moved and seconded. May we have a roll call, please, for the agency?
Agency members Friedman,
Yes.
Najarian,
Yes.
Quintero,
Yes.
Weaver,
Aye.
Chairman Nukian.
I'll move 1G for the authority.
Second?
Second.
Oh, I can't second, I'm the chair.
Second.
Roll call, please.
Authority members Friedman,
Yes.
Nukian,
Yes.
Mincy,
Yes.
Najarian,
Yes.
Brazilian,
Yes.
Weaver,
Aye.
Chair Quintero.
Yes.
Move we adjourn for the council.
Second.
Council is adjourned.
Move to adjourn for the authority.
Second.
Move to adjourn for the agency.
Second.
We're adjourned.
Redevelopment amendment.